Hi everyone, welcome to another episode of Legal Tuesdays. I am Monica Miller, the Legal Director and Senior Counsel for the American Humanist Association. In this series, I answer your questions about separation of church and state. We post the videos on our Facebook as well as our YouTube, and that's also where we collect questions, as well as from our online complaint form and our Legal Tuesdays specific complaint form. Today, I'm going to discuss Iowa's pending legislation that we've received several complaints about and that we're well aware of. And the legislation surrounds the required daily recitation of the Pledge of Allegiance in public schools. Right now, there is a bill, it's House File 415, that would require all K through 12 schools to administer the pledge daily and to show the U.S. flag while the pledge is being recited. So there's a question as to whether this type of law is constitutional and whether schools can force students to say the Pledge of Allegiance. Unfortunately, Iowa is not alone in passing legislation like this. It's actually unfortunately, it's very late to the game. It's actually one of only 3 states, Vermont and Wyoming being the other 2, that doesn't even already have legislation requiring or surrounding pledge participation in the public schools. About 30 states have statutes that make it really clear, I think maybe 32, that make it clear that students can opt out of the pledge. The rest of the states minus Wyoming and Vermont, they're ambiguous, and some of the states actually require, Florida and Texas require parents or guardians to give written permission for their children to opt out. Over the last, let's just say 5 years, we've received dozens upon dozens of complaints from students and parents across the country saying that that either they or their child had been compelled to say the pledge and receive some sort of punishment, whether it was just to kick them out of the classroom or actually get reprimanded with suspension or detention or something more serious. It's been pretty alarming, and the reason it's alarming is because it is unconstitutional to compel students to recite the pledge. So you can have a statute like Iowa's that says that that schools have to make this part of their morning practice. We have challenged this, and I'll get to that in a minute, but ultimately, under the current case law, those statutes would survive scrutiny. What doesn't survive scrutiny is how those statutes are applied. And like I said, we get complaints all the time from students saying that they were not allowed to opt out without comment. A teacher might have scolded them during class. And this goes against decades of binding Supreme Court precedent, starting with the most notable case, 1943, of West Virginia versus Barnett. Many people are probably familiar with that ruling. It was actually a Jehovah's Witness family that had brought the case, and it was before Under God was added to the pledge. And the Supreme Court still said that it is against the entire principle of the First Amendment to compel recitation of something like a Pledge of Allegiance. The exact quote, and I almost feel like I have it committed to memory, but it's been a minute. If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. So no compelled speech in the context of the pledge. You cannot, for instance, take a 6-year-old out of his chair when he's refusing to say the Pledge of Allegiance and pick him up and put him out in the hallway, which actually happened. And we were, I was horrified to see that was one administrator's response to a young student who was enlightened enough by his parents to sit for the Pledge of Allegiance and exercise his constitutional rights to do so, was met with that level of hostility and reprimand by public school officials. So although the statutes might be allowed, the actual conduct that teachers have employed to implement those statutes have been egregiously unconstitutional. And for that reason, I've sent, also dozens, about, I at least say 2 or 3 dozen letters in the last couple of years reprimanding public school officials for, of course, the 6-year-old example was quite extreme, but for taking measures against students for exercising their constitutional rights. We've also filed 2 lawsuits under state constitutions to challenge statutes very much like Iowa's. We've filed a case in New Jersey, as well as in Massachusetts. And in both of those cases, we actually challenged the daily pledge exercise as being violative not of the First Amendment's Establishment Clause, which those challenges have cropped up, and we've obviously supported them. They've had, unfortunately, very little to no success in the courts so far, challenging the under God language that was added in the 50s during the height of McCarthy's witch hunt against atheism. And actually the language was added at the push of the Knights of Columbus, a Christian fraternal organization. So no doubt the language was intended to combat atheism. And so when it's recited in public schools on a daily basis, they are affirming this belief that atheists are not patriotic, that we're one nation under God, and because atheists don't believe in God, that atheism and patriotism do not go hand in hand. And really it harkens back to the 1950s era stereotypes against atheists as being communists and evil and materialistic and anti-values. So the harm that's done to children through the rote repetition of these words under God on a daily basis in the public schools, we feel amounts to an equal protection, a discrimination type of claim. We didn't have success in the first two cases we brought. This was a long time ago. We kind of put a pin in it, but it's something that we'll likely revisit when the time is right. But what we did achieve in those cases was judicial confirmation from the highest courts. The highest court in Massachusetts, for instance, did confirm what we knew, but it was good to have it on the record with respect to statutes that compel daily pledge participation. The High Court of Massachusetts said, I think I pulled a quote just to solidify it. Yes. It is undisputed as a matter of federal constitutional law and as a matter of fact on the summary judgment record before us that no student is required to recite the pledge, and that the court would have found differently if that were the case. So I will end my remarks today with that, but I will speak to you at the next Legal Tuesdays segment.